Order. Order. Money motion. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it, the ayes have it. Ways and Means motion, Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it, the ayes have it. We now come to the motion to amend the order of consideration of the Lord's amendments to the Victims and Prisoners Bill. Copies of the motion are available in the Vote Office. Minister to move the motion formally.
I beg to move that proceedings on consideration of Lord's amendments to the Victims and Prisoners Bill shall be considered in the following order. Lord's amendments 35, 46, 32, 33, 47, 54, 98 and 99, 106, 1 to 31, 34, 36 to 45, 48 to 53, 55 to 97, 100 to 105, and 107 to 143.
The question is that proceedings on consideration of Lord's amendments to the Victims and Prisoners Bill shall be considered in the following order. Lord's amendments 35, 46, 32, 33, 47, 54, 98 and 99, 106, 1 to 31, 34, 36 to 45, 48 to 53, 55 to 97, 100 to 105, and 107 to 143. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it.
Victims and Prisoners Bill, consideration of Lord's amendments.
Now,
I must draw the House's attention to the fact that financial privilege is engaged by Lord's Amendments 33, 44, 56 to 60, 63, 64 and 142. If those Lord's Amendments are agreed to, I will cause the customary entry waiving Commons financial privilege to be entered in the Journal. We will begin with Government Amendment A to Lord's Amendments 35, with which we will consider the other motions as listed on the selection paper. I call Minister Edward Argar to move Amendment A to Lord's Amendment 35.
yeah.
Thank you, Madam Deputy Speaker, and it's a privilege to both move Amendment A, but to open this debate and bring the Victims and Prisoners Bill back. Slightly larger and more robust, a description that I fear after 9 years in this place could apply to my physique as well. A series of amendments were made in the other place, which we believe strengthen the intentions of the bill. May I, at the outset, express my gratitude to the Shadow Minister and indeed to the usual channels for their work in a very short time frame to ensure that we are able to proceed with this bill today. It is a pleasure to serve opposite the Shadow Minister. He knows not only the huge respect I have for him, but the fondness I have for him as well. And notwithstanding the 6 weeks of to and fro I expect we may have during the election, I want to put on the record that I genuinely wish him very well for the future. We strengthened victims' measures in this bill in the House of Lords at Lord's report stage to make it clear that compliance with the code is not optional and to bolster measures to hold agencies to account for its delivery. We also introduced measures to give a stronger voice to victims of offenders whose conditional release is considered by the Mental Health Tribunal, making it clear that victims who have signed NDAs can make disclosures to much-needed support services without fear of legal action, and raise the threshold for the disclosure of counselling notes for victims so they can now only be disclosed where they're of substantial probative value. We also tabled an amendment yesterday in the other place to create a new ground within Article 17 of UK GDPR, specifically for the victims of stalking and harassment, to request deletion of personal data related to false allegations. This amendment will help protect victims from further distress caused by the retention of this data, and I put on record my gratitude and tribute to the Honourable Lady, the member for Walthamstow, for raising this issue, for campaigning on it, and indeed to my friend, the noble Baroness Morgan of Coates, for pursuing this in the other place. Let me turn next to amendments to Part 3 of the bill, relating to infected blood. I am grateful, and I know this country will be grateful, to the Honourable Lady, the member for Kingston upon Hull North, for the work she has done, her tireless campaigning in seeking to expose and tackle this national scandal and ensure that those who have been the victims of it receive the support and the compensation they deserve. These amendments do three crucial things. They impose a duty on the government to establish a UK-wide infected blood compensation scheme within 3 months of royal assent. They establish a new arm's-length body, named the Infected Blood Compensation Authority, to deliver the compensation scheme. And finally, they impose a duty on government to make interim payments of £100,000 to the estates of deceased infected people where previous interim payments have not been made. And of course, I give way to the Right Honourable Lady.
I'm very grateful to the Minister, and I'm very grateful for all the work that he's done on these particular amendments. Could I just ask him, though, that final group, the ones who've received not a penny, the parents who lost children and the children who lost parents, we know that the government have announced an additional £210,000 to those infected to be paid within 90 days. There's no timescale for these payments to people who've not received anything yet. Is the Minister able to help the House to understand when these payments will actually be made?
Well, I'm grateful to the Right Honourable Lady, and I know that there are similar questions and that the Honourable Gentleman, the member for Glasgow South, I know has raised previously. I know that she and others are in correspondence with, I think, both the Prime Minister, my honourable friend, the Prime Minister, and indeed the Minister for the Cabinet Office. The questions raised are complex and detailed, and my understanding is that Robert Francis will be spending June having those conversations with communities and victims and families, so that in working out the answers to those questions, the detail of them, he can do that from the basis of what those families and communities want to see, rather than necessarily a minister or anyone else preempting that. One of the key lessons I, and I hope the government and this House, has taken from the work the Right Honourable Lady has done is the need to listen to those affected, and that is what Sir Rob will be doing. So I don't want to preempt that from this dispatch box. I suspect she may want to, in her speech, enlarge a little further on that. I'll let her come back on me, of course I will.
Grateful, and I would just gently like to point out to the Minister that Sir Brian Langstaff told the government in April 23, so that's over a year ago, to get on and make these payments. And I have to say to the Minister, there has been a lack of work could have been undertaken in that period to get to the point where payments could have been made quickly, and it's very regrettable that hasn't happened. Well,
I entirely note, and the House will have heard, and the country will have heard, the points made by the Right Honourable Lady in that respect. She will have seen, and I know she participated in the statement by the Prime Minister and the subsequent statement by the Minister for the Cabinet Office, which set out the work that he has undertaken at pace to make things move forward. I think what we see in this legislation is a hugely important step forward, and I look forward to Robert Francis working at pace to ensure that the views of those affected are genuinely reflected in the detailed answers to those questions that I know she has posed. Now, the government amendments, in my view, demonstrate our absolute commitment to delivering the long overdue justice to these victims. Too many people, whether they're infected or affected, have seen their life chances taken away, watched loved ones die needlessly, and endured the most terrible stigma, none of which should ever have happened. I can only hope, with the inquiry's report published and with our firm commitment to compensate those touched by the scandal, the infected blood community now knows that their cries for justice have finally been heard. And as I say, a lot of that is in tribute to the Right Honourable Lady's work. Government has also brought forward amendments to make reforms to those serving imprisonment for public protection and detention for public protection sentences. We will be further reducing the qualifying period to 2 years for those who were convicted when aged under 18, we will also allow the Secretary of State to have a discretion to decide that recall should have no effect on the 2-year automatic licence termination period, as well as requiring that an annual report be laid before Parliament on the support for those serving these sentences. I'm grateful to members of both houses for the constructive way they've engaged with this bill, and I'm delighted we will be able to complete its passage ahead of prorogation. I'll set out the detail of the motions we're bringing forward today in response to these outstanding issues. In respect of Lord's Amendment 35, we are seeking to amend the measure which relates to the issuing of guidance about victim support roles, now Clause 18. Victim support roles operate across different settings, some of which are devolved. The Senate did not grant legislative consent for this measure as previously drafted. I am therefore putting forward an amendment so the duty to issue guidance applies to England and reserved matters in Wales only, and have consequently removed the requirement to consult with Welsh ministers on any guidance issued. I'm grateful for the constructive discussions that have taken place in relation to the important principles that sit behind this clause, which aim to improve the consistency of support services provided to victims. And I'm confident we can continue to work together so victims have this consistency across both countries. In respect of Lord's Amendment 46, this is a technical amendment to move the location of the clause, child victims of domestic abuse, to the right part of the bill. Lord's Amendment 32, we have accepted the principle of this amendment, which will place a duty on relevant authorities to cooperate with the Victims Commissioner when requested. We heard the strength of feeling that a response to the Victims Commission, as they do their important work, should not be seen as a favour. Instead, there should be clear and open cooperation as an integral part of enabling the independent scrutiny that victims deserve. The Government's amendment makes a few minor changes. First, it extends required cooperation further than simply to assist the Commissioner in monitoring compliance with the Victims Code. Instead, it requires cooperation in relation to any of the Victims Commissioner functions, which include promoting the interests of victims and witnesses. Second, it adds important safeguards to make it clear that any cooperation must not only be practical, but also appropriate. This protects against, for example, potential interference with activities which are rightly independent, such as when exercising prosecutorial discretion. And third, it future-proofs the clause by putting this duty on the agencies who deliver services under the Victims Code, rather than including a specific list of bodies which may become out of date. Lord's Amendment 33 seeks to require training to be provided to those with obligations under the Victims Code. Now, of course, agencies should and do have training in place to deliver the legislative duty to act in accordance with the Code, but that training must be tailored to the specific function that each person is discharging, and agencies are best placed to do that. By placing an additional burden on the Secretary of State to implement a strategy of training, we consider this amendment would be costly and inefficient. It would not be proper for an amendment from the laws to place financial burdens on public authorities, and we also consider the more effective approach, as has been committed by the Government in the other place, is to include a requirement for agencies to report on the adequacy of their code training as part of evidencing delivery of code entitlements. This gives us a route to identify and address ineffective training if it has led to non-compliance with the code. Lord's Amendment 47 seeks to establish an immigration firewall and prevent the police from sharing data relating to immigration status with immigration enforcement. We're disagreeing with this amendment because it would be inappropriate to impose a blanket restriction on the use of personal data in the circumstances to which the amendment relates. It would not prevent the perpetrator from informing immigration enforcement about the victim's immigration status and would impact on the ability to investigate crimes and support victims. Turning to Lord's Amendment 54, this seeks to place a statutory duty of candour on all public authorities, public servants and officials after a major incident has been declared in writing by the Secretary of State. The Government shares the desire to see an end to unacceptable institutional defensiveness. However, we cannot accept the amendment in its current form, as it would not sit neatly on top of the existing frameworks. It is not well suited to replace what already exists, both in the context of major incidents and beyond, and it doesn't take into account the nuances of different professions in the spheres of the public sector and could entail significant legal uncertainty. This area is complex, and we believe it would be unwise to rush forward with an amendment for these reasons. Therefore, however, we have tabled an amendment to require a statutory review to determine whether additional duties of transparency and candour should be imposed on public authorities and public servants in relation to major incidents. This review will need to be completed by the end of the calendar year, and following its completion, a report laid before Parliament, which it will be for whichever government is elected in 6 weeks' time to determine what to do with. We are also bringing forward an amendment in lieu to Lord's Amendments 98 and 99. The Government amendment would ensure that those convicted of controlling or coercive behaviour who are sentenced to at least 12 months imprisonment will be automatically subject to management under multi-agency public protection arrangements, MAPA, thereby ensuring that we are effectively managing and targeting the most dangerous domestic abuse offenders. A previous amendment was tabled to the bill in the other place to add domestic abuse and stalking perpetrators to those who qualify for automatic MAPA management. While there is a legal definition of domestic abuse, a specific domestic abuse crime does not exist, with the exception of controlling or coercive behaviour. Therefore, though well-intentioned, this would still have required criminal justice agencies to decide on a case-by-case basis whether an offender is eligible for MAPA management, and consequently would not have achieved the intention to reduce or eliminate any scope for local discretion. There are already provisions in place which require offenders on licence to live only at an address approved by probation. Further, all offenders released on licence are subject to standard conditions for the duration of their sentence, and there are numerous additional licence conditions which can be imposed to address specific risk factors. Licence conditions allow for information on perpetrators to be collected and used to manage risk. This amendment will have little added public safety impact, but will result in a significant resourcing pressure for police forces. Offenders who perpetrate other forms of domestic abuse, such as threats to kill, actual and grievous bodily harm, attempted strangulation, putting people in fear of violence, and stalking, including fear of violence or serious alarm or distress, are already automatically managed under MAPA, if sentenced to 12 months custody or more. Adding the additional offence of controlling and coercive behaviour will ensure the most harmful domestic abuse offenders will be automatically covered by these arrangements. These changes will mean these offenders will be automatically managed in the same way as those convicted of sexual, violent and terrorist offences. This is crucial as controlling or coercive behaviour is a known risk factor for domestic homicide. Treating these offenders in the same way as the most violent offenders is critical for improving the safety of domestic abuse victims. Lord's Amendment 106 will permit the Secretary of State to re-release recalled IPP prisoners and mirrors the power that the Secretary of State has to re-release offenders serving determinate sentences, now referred to as Risk Assess Recall Review, RAR. This is an executive power, and it will be for the Secretary of State to decide if or when to use it. We've also included an amendment to enable the Secretary of State to impose licence conditions in a recalled IPP offender's licence if the Secretary of State uses this power to release them on licence. We agree this is the right approach. However, we are bringing forward amendments in lieu to make this amendment, together with further measures relating to release, which come under the scope of this clause, this amendment. The Government amendment brings an amendment in lieu to also extend the eligibility of the home detention curfew scheme to offenders serving sentences of 4 years or over. The original aim of the scheme was to help suitable lower-risk offenders who have been in custody to reintegrate into society in a controlled manner. As sentences have become longer, it is important that we revisit whether eligibility for HDC continues to allow all those who may be suitable and who would benefit rehabilitatively from the scheme to be considered as originally intended. This means looking again at whether offenders who are excluded solely due to sentence length or old curfew breaches, rather than any assessment of risk, should be able to be considered in the usual way for HDC. Since HDC was introduced, sentences have grown longer and should no longer be the sole determinant of whether or not someone is eligible to be considered for HDC. A 4-year sentence length or old curfew breach is a very blunt measure of whether an offender is lower risk or suitable for HDC. While this amendment increases the number of offenders eligible, it does not extend the range of offences which make an offender eligible for HDC. All sexual offenders and serious violent offenders are excluded from the scheme, as are those subject to parole board release. Those convicted of offences often associated with domestic abuse, such as stalking and harassment, are also excluded. So are many other people, including Category A prisoners. There is also a robust risk assessment to ensure that offenders are only released if there is a plan in place to manage them safely in the community. And in every case, this includes a curfew backed up with electronic monitoring. And finally, Amendment 46 is a technical amendment to move the location of the clause, child victims of domestic abuse, to the right part of the bill. Madam Deputy Speaker, I would like to take the opportunity to put on record my gratitude to the clerks, the Shadow Minister, and to all my officials who have worked on this important piece of legislation. Nicky Jones, Katie Morris, Donna Bromyard, Elizabeth Bates, Isla Scott, Emily Halliday, Claire Anderson, Thomas MacDonald, Anna Webb, there's a few more, Madam Deputy Speaker, Alex Brown, Gabby Perrot, Liam Walsh, Ava Bassani, Jess Cowan, Michael Rimmer, the OPC drafters Joel and Camilla, and my amazing private secretaries Ben Street and Amelia Brzezinski. They have done an amazing job on this piece of legislation. This, as I've said to the House before, this bill has a central objective to ensure victims are treated like participants in the justice process rather than bystanders. The bill delivers significant and positive changes, strengthening victims' rights and the role of the Victims Commissioner, providing protections for victims, creating an independent public advocate, and I pay tribute to the Right Honourable Ladies and Member for Garston and Halewood and Maidenhead for their work on this, creating that arm's-length body to finally move things forward in respect of compensation for infected blood scandal victims and reforming the parole system, as well as bringing forward reforms for IPP prisoners. The bill has been a long time in the making, but getting it into law will be a major step forward, strengthening the voice of victims of crime and those who are victims of major incidents in our criminal justice system. Madam Deputy Speaker, given that this will be the last time I am at this dispatch box in this Parliament, and my last time speaking in this chamber as the Member of Parliament for Charnwood, because the seat I've been proud to represent for 9 years is abolished in boundary changes, although I hope to be returned as the member for the new Melton Syston constituency in the forthcoming general election. May I also take the opportunity to thank you, colleagues, but also particularly my constituents in Charnwood and my fantastic staff, Steph Bradshaw and Fred Seaman, who do so much for those constituents day in, day out. And with that, Madam Deputy Speaker, I beg to move.
Amendment A, proposed to Lord's Amendment 35, as on the notice paper. The question is that Amendment A be made. Shadow Minister Kevin Brennan.
Thank you, Madam Deputy Speaker. This is the last time I intend to speak from this dispatch box in any Parliament, Madam Deputy Speaker. Actually, I've got one more essay to do, so that may not be quite true. Madam Deputy Speaker, thank you very much for calling me to speak, and can I take the opportunity to thank you for your service to this House in many different capacities over the entirety of my parliamentary career. And I hope it doesn't cause offence in any other quarters if I say to you that you are my favourite Deputy Speaker. And I'm sure others might share that opinion, but that's of no way casting aspersions on the quality of your colleagues. But we have known each other and been friends for many years, and I wish you every good fortune in whatever you do next after you leave this place, Madam Deputy Speaker. And can I also extend equal thanks to the Minister for the way in which he conducts himself as a government minister. I think it's exemplary, the way that he deals with colleagues across the House, with shadow ministers, with backbenchers, with others. He's a class act in that regard, and I think a model that many of us should aspire to. I've been a minister before, and I know what a difficult job it is, but I know what a difference it makes if you have a minister in a department that actually takes Parliament seriously, takes what members of Parliament say seriously, and does their best when it's possible to accommodate opinions and measures from other members of Parliament, and doesn't think that the government always has every doesn't have a monopoly on wisdom or on measures when they bring a bill to this House. He's prepared to engage in debate and consider amendments, and I thank him for the way in which he conducts himself in this place. And while she's here, Madam Deputy Speaker, since she's sitting there, and I know she's leaving this place, the member for Cities of London and Westminster, who many years ago, some members of the House may be aware, was a pupil at Rada Comprehensive School when I was a teacher at Rada Comprehensive School. Little did I think that she would be leaving this House before I'd be leaving this House, given that fact. But all would end up as a Conservative Member of Parliament. I was obviously a lousy teacher, Madam Deputy Speaker, because she ended up as a Conservative Member of Parliament. But can I wish her well in the future as she leaves this place, and indeed the Chair of the Justice Committee, who's also a friend across the House, and again conducts himself in a manner that I think we could all aspire to. As we stand here at this critical point, I think we are reminded of how significant this bill is. I'm pleased that the government's come to their senses and given the British public an opportunity to go to the polls and have their say on who's going to run the country. But I don't believe that should be at the expense of victims. And that's why, we welcome the discussions that have taken place through the usual channels and that we've arrived at today. So we will be supporting the measures as outlined by the Minister. These are victims who've waited over 8 years and through 8 Justice Secretaries, in fact, to have a piece of legislation directed towards addressing some of the failures and injustices that they face. And supporting victims is a priority for us on this side of the House, Madam Deputy Speaker, and in the spirit about bringing overdue changes to our criminal justice system and beginning that work of trying to restore public confidence in it, we're pleased to support the bill. And we've strived to be collaborative through the process, and I think the Minister's acknowledged that, and we do wish to recognise the government's willingness to negotiate in the final hours of this Parliament. With that, I'd also like to take this opportunity to acknowledge the exemplary efforts of my predecessors who did most of the heavy lifting on this bill before I took this role. The Honourable Member, my neighbour, the Honourable Member for Cardiff North and the Honourable Member for Lewisham West and Penge in particular. And I also extend my thanks, as I've said already, to the Minister for the cordial and constructive approach they've taken throughout this process. We are resolute in the Labour Party, Madam Deputy Speaker, in our commitment to put victims back into the heart of the criminal justice system, and we recognise the importance not only of listening to them, but going further to deliver robust support, empowering them and enhancing their rights. On the duty to collaborate with the Victims Commissioner, which the Minister outlined in his speech, it's always heartening to know that the hard work conducted in opposition does get recognised sometimes and ultimately utilised to the benefit of the public. So the success of Lord's Amendment 32 to introduce a duty to collaborate with the Victims Commissioner is a perfect example of the effort exerted by the opposition paying off. Labour's been clear that it's imperative that we strengthen the powers of the Victims Commissioner, and although we've sought to go further than we've been able to do from opposition, we recognise that the new duty on justice agencies to cooperate with the holder of that role is a useful start. We remain committed to recognising the significance of the Victims Commissioner and the desperate need for that office to be strengthened. It's long past time for the system to be truly accountable when the needs of victims are not met. So we're glad this is a step forward towards a fully empowered Victims Commissioner. We've listened to the calls of previous commissioners and victim support services, and we'll continue to do so, and we're firmly committed to further strengthening the Commissioner's powers should we have the privilege of sitting on the Treasury benches in a few weeks' time. On the issue of major incidents and the duty of candour, which the Minister also referred to in Part 2 of the bill and the provisions concerning the victims of major incidents, we were pleased to see that our colleagues in the other place understood the importance of the introduction of a duty of candour for public bodies with Lord's Amendment 54, and I'd like to thank my colleagues in the other place for their hard work, particularly Lord Ponsonby, our front bench representative, for his evidently persuasive contributions in moving this amendment, and I welcome the statutory review that's been announced by the Minister in the government's own amendments. Labour's committed to introduce a statutory duty of candour. It's as simple as that, and we're absolutely committed to ensuring that public authorities and officials cooperate with official investigations in the wake of public disasters, as they should if they are to act in the public interest. In the wake of several high-profile and devastating miscarriages of justice, this is more important than ever. Only then can we ensure that we end evasive and obstructive practices following state-related deaths. While we have to date been dealing with a government that's, I hope he doesn't mind me saying, dragged its feet a bit on this issue, we've at last had the opportunity to secure an agreement on the face of the bill, and it now only remains to finalise the all-important last details of how that duty of candour will work in practice, which Labour will work on from our earliest days in government. If we win the election, we will make this change. Turning to the infected blood scandal, it would be remiss not to refer to my constituent, Sue Sparks, who visited the House this week and was, I think it could be described as, at first elated by Sir Brian Langstaff's report when it was announced, but then described to me how she became deflated as the government made its statements to the House regarding the compensation. And I just have to say, you know, in complete agreement with my right honourable friend, the member for Kingston upon Hull North, who I've worked with for many, many years, actually, long before I took this role, on this issue, that she's absolutely right in what she said. And I remember both her and I on that backbench calling a year ago for the government to get on with the design and the payment of these compensation payments to the victims. And I too am very, very sad that that work hasn't been done. In the meantime, it would appear. I'll give way to the honourable gentleman.
I'm very grateful to him for giving way and showing his typical generosity on this. Does he not also agree with me? It's very important now that very quickly the Cabinet Office needs to meet and engage with the infected and affected community to make sure that that compensation payment is right, but also ensure that that community is represented in the Compensation Authority Board.
Yes, as he often is. The honourable gentleman's absolutely right, and I completely endorse his remarks in his intervention. And I thank him for the £50 he's going to pay to charity for losing a bet with me that there would be a referendum on Scottish independence by the end of this Parliament. And he's very... And I put this on the record. It's not that I don't trust him, but I put it on the record because I've said I'll send him the name of the charity after today's debate. And I know he's a man of honour and a man of his word, and will pay up on that score. But I thank him also for his... On a serious point, I thank him also for his contribution on this very, very important issue. And I know, you know, his background in the trade union movement. This means he's someone who will always be thoughtful for people who are, for the essential job of helping the weak against the strong, which is what we're trying to do really in this place. I should also pay proper tribute to my right honourable friend. Her original amendment, in fact, earlier, a few months ago, caused the government, I think, to suffer possibly the only defeat it suffered in this House in the course of this Parliament when she put down an amendment to hold the government's feet to the fire on this very issue, and that is quite an achievement. To echo Sir Brian Langstaff, we must tackle the lack of openness, transparency and candour which has left victims suffering for decades. So we do welcome the movement towards this important milestone, and we look forward to seeing victims get the financial redress they deserve sooner rather than later. And I should say that my constituent Sue Sparks, it was her husband Les who died in 1990 as a result of receiving infected blood. On the issue of IPPs, Madam Deputy Speaker, there's been a lot of discussion and work conducted by colleagues of all parties to recognise the considerable concerns surrounding sentences of imprisonment for public protection, IPPs. They are a stain, they were a stain on our nation's criminal justice system, and we've acknowledged our role in that as well in the past. It's right that IPP sentences were abolished, and we share the concerns that lie behind many of the proposals that were suggested by colleagues here and in the other place in relation to these sentences and these particular prisoners. We've continually sought to work constructively and on a cross-party basis wherever possible on this issue, which is why we're pleased to support multiple government concessions on this matter in the Lords, including Lords Amendments 103 and 107, agreeing to a new annual report and provisions for those sentenced to detention for public protection. And I do pay tribute to our colleague Lord Blunkett, who did a great deal of work to undo perhaps some of the things he might have been responsible for many, many years ago. But progress for those remaining on IPP sentences and on licence in the community is pivotal. And we want to ensure that any solutions proposed are robust, that they're assessed with public safety properly in mind. As the Minister quite rightly said, and in government, Labour will work at pace to make progress and will consult widely to ensure that our actions for those on IPPs are effective in their interest and based on the evidence that is in front of us. On the MAPA issues in the bill, we're very glad to have agreed on an overdue and important change in the arrangements that are in place to protect for victims and the public from the terrible blight in our society that is domestic abuse. When this bill passes, offenders sentenced to more than 12 months for the offence of controlling or coercive behaviour will now be automatically included in the multi-agency regime that exists for the violent and sexual offenders. And this follows strong support in the other place, Madam Deputy Speaker, for more rigorous safeguards in these sorts of cases. Where we too often see women in particular left to face repeating and escalating patterns of abuse within the relationships where they should be most safe. Labour has got big ambitions in government, Madam Deputy Speaker, to tackle violence against women and girls in particular, far beyond the commitment in this bill. But we are nevertheless proud to put this marker down and to support this measure. And in conclusion, Madam Deputy Speaker, our commitment to reforming the criminal justice system to ensure victims are more than just bit players is unwavering. We're pleased to have supported and helped to improve this bill. Our essential additions, from empowering the Victims Commissioner to introducing a duty of candour for public bodies, have highlighted Labour's commitment to the rightful place of victims at the centre of the justice process. We welcome the government's movements in the right direction on pivotal issues such as IPPs and on the Infected Blood Compensation Authority, notwithstanding the remarks I made about the slowness of movements to get that compensation out to victims. But I do thank the Minister for his openness in accepting some of these changes. I look forward to the bill's conclusion very shortly, I hope, and I hope it will be an act that is a step forward towards a new era of transparency and advocacy for all victims of crime.
Chair of the Justice Select Committee, Sir Robert Neill.
Thank you very much, Madam Deputy Speaker, and may I start by wishing you the very best as we leave the House together. And I remember, as a keen young opposition spokesman, being your shadow when you were local government minister, and I could never have had a more charming or skillful opposite number, and I learnt a lot from that, and I wish you the very best for the future. I see too, sitting behind me, two of my oldest friends in politics, the honourable members for Wimbledon and the cities of London and Westminster. We've been around the block, literally, in some in various local government campaigns in London over many, many years. And it is a certain irony that we've all decided to depart at the same time. And it will be probably cause for a good lunch at some point. But I haven't forgotten I owe the Minister one as well, because I did want to pay tribute to the Minister for the approach, because I totally agree with the Shadow Minister, to whom I'm also very grateful. He's been a good friend in relation to this, and issues like performing arts, music that we both championed here as well, and the SNP spokesman. The Minister's been exemplary in his approach to this. We're actually very fortunate, Madam Deputy Speaker, in the team of ministers that we have currently at the Ministry of Justice. My right honourable friend, and although he's not here today, his name's on the amendments, my right honourable learned friend, the Secretary of State and the Lord Chancellor, a quite exceptional lawyer, quite exceptional Lord Chancellor, a star in this chamber, and somebody whose integrity and commitment to the legal system will be long recognised. This is an improvement to the bill. I'm glad of that. Can I thank too the Ministry of Justice officials, because I've dealt with many of them over the years, and I'm sorry if they've put up with some of the things the Select Committee has lobbed at them over the time, but there's always been a great constructive spirit. And in this context, I particularly welcome the fact that the Government have taken on board a number of the recommendations that the Select Committee made, both in relation to our pre-legislative scrutiny, what was then simply the Victims Bill, and then also, when it became the Victims and Prisoners Bill, some, although not all, of our recommendations in relation to IPP prisoners, and more of that in a moment. The scrutiny on the Victims Bill was particularly led by the Right Honourable Lady Member for Garston and Halewood, who served as my deputy on the committee before she was very rightly recalled to the opposition front bench. And I wanted to thank her too for the support that she gave me on the committee and for the particular work that she did for her constituents and for a better and fairer approach for victims in these cases. And I also congratulate the Right Honourable Member for Kingston upon Hull North, who I first met when we were both elected to the London Assembly in 2000 for the exceptional work that she has done in relation to infected blood. It's one of those things where we can work across parties on these matters, and she's performed a great service. In relation to just some of the remaining parts of the bill, I'm glad that the Government has moved in relation to the matters that are set out here. The cooperation with the Commissioner is good news. The duty of candour, I think we all know, is valuable and to be welcomed. Perhaps it could go further, but let's accept that that's a step in the right direction. The use of public protection, the powers in relation to recalled prisoners and extension of home curfew are sensible measures. Home curfew is important because, I'll say it yet again, because I may not have another chance, we need to be more intelligent as a society in the way in which we use imprisonment, which is expensive and in the way we use it at the moment, not always effective. Alternative tools in the sentences box, including the use of home detention curfews, enable us, I believe, to get a better approach to balancing punishment, which is legitimate, but also with rehabilitation, which is what we have to aim for if we are going to reduce reoffending. Because if you want to reduce the number of victims of crime, you want to reduce the reoffending. And home detention curfew and other measures are in themselves a valuable step towards doing that. And by no means the whole answer, but any advance is something. And my regret, unfortunately, is that in the wash-up we do not have the sentencing bill returning, because that would have taken many, many more valuable steps to have a more balanced and rational approach to sentencing policy. I think it's very regrettable that has not returned. I hope whoever is in government after the general election will return to the issues in the sentencing bill, because a lot of them actually had cross-party support, and I hope we will see those come back. Can I then perhaps just mention IPP prisoners, because that, again, is a campaign where there has been massive cross-party support, both here and in the other House. Our committee took very compelling evidence on it. In particular, I want to thank those who've championed this in the other place. My good friend, the Noble Lord Moylan, Lord Blunkett. I wish the government had gone further and introduced the proposal for a resentencing exercise that was put forward very powerfully by the Noble Lord Thomas of Cungeath, the former Lord Chief Justice. I still think there is merit in that. And I wanted to end by paying tribute to someone who sadly can't hear the words. Because yesterday I was at Middle Temple for the memorial service for the late Lord Brown of Eton under Haywood, one of the most exceptional men I have ever met, an exceptional lawyer, one of the last of the Lords of Appeal in Ordinary, the Law Lords, one of the first of the Supreme Court, and who at an age when many people would be putting their feet up, was regularly in the House of Lords until a month before he died, and championing regularly the case of IPP prisoners, and coined that phrase, the stain upon the justice system. Simon's words. And what I hope one day is, you'll be pleased, I hope, wherever, to have heard those words from the Minister, that there will be movement, but I hope we'll go back and what we'd once termed the Simon Brown Memorial Amendment, which would actually give the resentencing exercise, will be returned to, because that exceptional person who inspired me and many others, and his family, would deserve that, because if it's possible to be both a lawyer, a public figure, and a great human being, Simon Brown epitomised that, and that's something perhaps we can all learn from.
SNP spokesperson Chris Stevens.
Well, thank you very much, Madam Deputy Speaker. It's a pleasure to follow the chair of the Justice Select Committee, and can I wish him all the best for the future, and to thank him for all the work he did as chair of the Justice Committee. I think one of his memorable moments, perhaps, in the last few months is to have chaired the Justice Committee in which myself and my honourable friend for Edinburgh South West were pushing the issue of the Horizon Postmasters in Scotland and what that meant for us. And I think that was actually a very intelligent session with many legal experts, and I think that he chaired that in an exemplary way and allowed that debate to continue. And I've always found him to be one of the more interesting members of the House when it comes to discussing matters like this, and I've always found him to be very fair, and I would like to wish him all the best. As I would like to wish you, Madam Deputy Speaker, all the best for you in the future. And I, like the Labour front bench, I'm going to name you as my favourite Deputy Speaker. Madam Deputy Speaker, you always used to tease me that I have a glint in my eye before I'm ready to speak in the chamber, and I think that I would always be kind of coy when you were suggesting that I was going to be speaking next. But genuine good wishes to you, Madam Deputy Speaker, and I want to thank you for all the kindness that you've shown to me as an individual, and all the encouragement that I think you give all honourable members of the House in order to carry out our duties, both to our constituents and here in the chamber. Madam Deputy Speaker, what an amazing week it's been. We find ourselves having to, and it was suggested that this bill might not make the wash-up. And I think if that had been the case, there would have been an almighty furore from the infected and affected blood community, because it did look like this was not going to make it. And I think that it was pressure applied by members in this House, members in the other place, and indeed the campaigners, to make sure that we get this bill over the line. And I'm going to confine the rest of my observations very much to the amendments in relation to the Infected Blood Compensation Scheme and setting up the Infected Blood Compensation Authority, which I welcome. I welcome that part of it, and I have, as I did earlier on in the week, the appointment of Sir Robert Francis to be the head of the Infected Blood Compensation Board. I think that was, and authority, I think that was very much an excellent appointment. But I'm here, Madam Deputy Speaker, to fulfil a constituent commitment, as many others have, and in particular Cathy Young and her two daughters, Nicola and Lisa. It was one of my first constituency cases. It was when Cathy Young came to see me in Darnley Community Centre. And I had known a bit about this issue, because obviously in Scotland with the Penrose inquiry, which was untidy, I think, to say the least. But I got more and more interested and more passionate about this, because this was a clear injustice. But I think the pity about this, and I'm a great believer, as the shadow front bench suggested, when it's time for an election, you don't run away from it or shy away from it. It's time for the election. But I do think some of the events in the last couple of days, in which on Monday, when my constituent Cathy Young was down here in London along with her daughters, I think some people in the government knew that the general election was going to be called 2 days later. And I think that the same people probably knew the general election was going to be called when the pay, and I don't believe the Paymaster General did, but when the Paymaster General was on his feet delivering a statement about what the compensation scheme would look like. I do believe there are some people in the government who knew the general election was going to be called the very next day. And I think we're in an unfortunate position, Madam Deputy Speaker, and that there are a lot of questions now that need answered and clarified, I believe, before Parliament is dissolved. And I'm going to raise some of them here, because we do seem to be in a bit of flux, which I think is a pity. But I'm going to take this opportunity on behalf of my constituents and the infected blood community, who have taken members of this House to their hearts, as we have taken them to our hearts. First question is, it looks like, according to the scheme and the discussions that have taken place with the Cabinet Office, that the parents of a deceased infected child will receive the same amount as a living infected child. That doesn't seem to be too right to me, and I do think that that needs clarified. There's also no mention of the VCJD infection in amongst all this paperwork. There's a lot of clarity needed on the confusion between what's a widow's payment and an estate's payment. The expectation appears to be that widows are going to distribute the money paid as an estate payment. Well, that's going to be difficult for those of us who know, because unfortunately the sad reality of life is that some families don't speak to each other for all sorts of reasons, and I think that's going to be difficult. It's suggested that widows would receive £16,000. That seems to be less than the money they're getting at present. Support for distressed people, the support scheme payments, which are going to end. This is leaving a lot of people, Madam Deputy Speaker, in clear distress. People are very worried about losing monthly payments from these support schemes, and it is suggested by the government that these support scheme payments will end, and we certainly need clarity, and certainly there needs to be more discussion with the infected and affected blood community in order to ease some of those concerns. We also need clarity clearly for individual heads of loss for the infected, because frankly we would all seem to be in the dark. There's also an omission of the uplift for psychological effects. Will that be covered by the Injury Impact Award? At the moment that is not clear, but that is clearly something that we would want to discuss. I think there also needs to be discuss about what the psychological support services should be going forward, because this has been a difficult week and a very emotional week for many people. And lastly, Madam Deputy Speaker, and I think this is very important, is that if people accept the interim payment of £210,000, does that mean that they then are accepting all of the compensation values that are currently on the UK Government website? So it seems to me there's a lot of clarity and a lot more discussion needs to take place. I welcome the fact that this authority has been set up. I welcome the fact that I think this House, being at its best, has forced government to move on this particular issue. There were just as many people on the Conservative side who voted for the amendment by my good friend, the Right Honourable Member for Kingston upon Hull North, as there was in other parts of the Chamber. That has to be recognised that this is a collective cross-party attempt to address this injustice. And I hope that those questions will be answered either in writing or in discussions with that affected and affected blood community, because we are all here, I believe, to make sure that they get the justice they so richly deserve. And just to make the point that any further delays will make that justice denied. Thank you.
Dame Diana Johnson.
Thank you, Madam Deputy Speaker, and it is a real pleasure to follow my honourable friend from Glasgow South West, and I just want to thank him for all his excellent work over the years on the issue of infected blood and the important role he's played in the all-party group to get to where we are this week. So a very big personal thank you to him. I also just want to comment on the remarks of the Chair of the Select Committee, of the Justice Select Committee. And I just wanted to say to him, I'm very sad that he's leaving the House. And I've looked up to him, actually, as an excellent role model of how to chair a Select Committee, with grace and charm, but actually with steel as well. And he hasn't shied away from the scrutiny, the effective scrutiny, that I think is so vital to the functioning of this House through the Select Committee system. And I just want to wish him all the very best for what he goes on to do next. And I wondered if I could, at this stage as well, as we're talking about Select Committees, just pay tribute to the Home Affairs Select Committee, the members, some of whom may not return to this House, but I want to wish them all the very best for all the work they've done as Select Committee members, and pay tribute to the work of the clerks and the staff of the Home Affairs Select Committee over the last 2.5 years that I've had the great honour and privilege of chairing it. And in particular, I want to mention Joe Dodd, our current clerk, David Weir, who was our previous clerk, and also Mariam Keating, who's been a second clerk who stepped up when we needed her to, when we had an interregnum between our first clerks. So I want to thank all of those. Now, the remarks I want to make today about the Lord's amendments are very much on the spirit, actually, of what's been said in terms of the infected blood scandal. And as the Honourable Member for Glasgow South West said, what a week this has been. We started on Monday with that report from Sir Brian Langstaff, 6 years of evidence heard by that independent public inquiry, and damning, absolutely damning, of the role of doctors, of the NHS and of the state, and a vindication for all those campaigners over the years, over the decades, that finally we have the truth. And in that room across the way at Westminster Central Hall, there were a lot of ghosts in that room, a lot of people who should have been there, who weren't. And I just want to pay tribute to someone I got to know, Nick Sainsbury, who lived just outside Hull, who had been a pupil at Trelaw's boarding school, was a haemophiliac, and who was infected with hepatitis C and HIV as a young boy. And he spent his life campaigning to try and find out what had happened and to get justice. And very sadly, he died last year before the final report was published and he could see the start of justice for those who'd been infected and affected. And I also just want to pay tribute to Glenn Wilkinson, my constituent, who started this all off for me back in 2010. At a very similar time to this, a general election had just been called. It was my final surgery as an MP, and he came to see me. And I've actually learnt now that he was so disillusioned with everything, he almost didn't come to see me at that surgery. And I said to him, well, if I get re-elected in the next Parliament, I will try and help you. And that started the journey of 14 years working with Glenn and so many others on this campaign. Now, and the other person I want to put on record is Caroline Wheeler, the political editor of the Sunday Times, who relentlessly has used her position as a journalist to shine a light on this, who has written a book, who has been all the way making sure that politicians can't forget what happened and this search for justice. So a big thank you to Caroline Wheeler. Now, turning to these Lord's amendments, I want to thank members of the other place and the ministers and the shadow ministers for all the work they've done. But I do want to just remind this House how we ended up with this in the bill, this section of the bill. The 4th of December last year, this House defeated the government, 246 votes to 242. And why did that happen? That happened because Sir Brian Langstaff, in April 2023, had made his second interim report, and in it he said in all conscience he could not wait to tell the government that they needed to start to pay compensation. He said wrongs had been done at an individual, a collective and a systemic level, and that people were dying. We know currently people are dying at the rate of one person every 3.5 days. So Parliament defeated the government because, and I'm really proud of this Parliament for doing that, because the government weren't doing what they should have done, and Parliament made them act and put into this particular legislation that this provision should be in there, and started this whole process off. And it was cross-party, and I think that's really important to note. Madam Deputy Speaker, do I need to curtail my remarks? I can see...
I'm conscious that the debate has to finish at 51, and I do that.
I absolutely agree with everything that my honourable friend has said about the questions that still need to be answered. I think one thing I do want to raise is Sir Robert Francis and the engagement that will be taking place in the next few weeks. Legal representation is needed so people can fully engage with that process and make sure that they are feeding in the real issues around the tariffs that have been produced, which has caused a lot of concern and worry. That's the main thing I want to say. And also, we need to get on with psychological services in England. We've got them in Scotland, Wales and Northern Ireland. We now need to get them in England, and I hope the Minister will take that message back. And the support payments, the other key issue. Thank you.
Thank you, Madam Deputy Speaker. I want to associate myself with everything that's said about infected blood, but I also want to call to the attention of this House the cross-party working on Amendment 45, in particular the work of Baroness Morgan, Baroness Finn, Baroness Brennan, but also Baroness Thornton, Lord Ponsonby and Lord Russell in the other place to protect victims of malicious harassment. I also want to thank the Minister and the Minister's team, because he knows this has been an issue that many of us have been vexed about because we've been victims of it ourselves. He has been patient and he has recognised that we simply couldn't say this won't happen again. We did need to put something into law. In that sense, I also want to pay tribute to all the lawyers who have assisted us, the stalking experts. And I don't think we can let this bill go through this place without acknowledging the work of the Victims Commissioner for London, Claire Waxman, who is sat in the gallery this afternoon, who has tirelessly fought for victims' legislation. I just have a few questions about Amendment 45. I wouldn't be taking part if I didn't. Amendment 45 is about stopping harassment. When somebody makes malicious complaints about you, even if they are convicted, at the moment it isn't clear for many data controllers that because those records have been created by a process of malice, they should be deleted. As a consequence, victims find themselves being pursued by those records. The new amendment will give a direct right to request a deletion for that sort of process, the Minister will know there is a concern that some of the exemptions could be broad. I wonder if he will just commit, as was done in the other House, to giving clarity as to when those exceptions cannot be used with malicious complaints and give protection to those victims who are targeted in this way. Many of us in the public realm will be so. We've got an election coming up and we know that this will happen. Many of us want to face public scrutiny, but we recognise that our families should not have to pay the price for it. And so often with these records, that is what happens. So I just wonder if the Minister could, in his summing up remarks, commit to that formal guidance.
I'm afraid the Minister will not have time to sum up, but I'm sure he will be in touch if there is anything he wishes to add. Order, order. Under the business of the House motion agreed yesterday, I must now put the questions necessary to bring to a conclusion proceedings on the Lord's amendments. The question is that Amendment A be made to Lord's Amendment 35. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Government Amendments B and C to Lord's Amendment 35. Minister to move formally. The question is that this House agrees to Government Amendments B and C to Lord's Amendment A. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. I call the Minister to move that this House agrees with the Lords in their Amendment 35 as amended.
I beg to move.
The question is that this House agrees with the Lords in their Amendment 35 as amended. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government Amendment A to Lords Amendment 46. Minister to move formally.
Madam Deputy Speaker, I beg to move.
The question is that this House agrees to Government Amendment A to Lords Amendment 46. As many as are of that opinion say aye. 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 Contrary, no. I think the ayes have it. The ayes have it. I call the Minister to move that this House agrees with the Lords in their Amendment 46 as amended.
I beg to move.
The question is that this House agrees with the Lords in their Amendment 46 as amended. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Lord's Amendment 32. Minister to move the motion to disagree formally.
Beg to move.
The question is that this House disagrees with the Lords in their Amendment 32. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Government Amendment A in lieu of Lord's Amendment 32. Minister to move formally. The question is that this House agrees to Government Amendment A in lieu of Lord's Amendment 32. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Lord's Amendment 33. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 33. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Lord's Amendment 47. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 47. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Lord's Amendment 54. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 54. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Government Amendment A in lieu of Lords Amendment 54. Minister to move formally.
I beg to move.
The question is that this House agrees to Government Amendment A in lieu of Lords Amendment 54. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Lord's Amendment 98. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 98. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Lord's Amendment 99. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 99. As many as are of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to Government Amendment A in lieu of Lords Amendment 98 and 99. Minister to move formally.
I beg to move.
The question is that this House agrees to Government Amendment A in lieu of Lords Amendments 98 and 99. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to Lords Amendment 106. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 106. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to Government Amendments A and B in lieu of Lords Amendment 106. Minister to move formally.
I beg to move.
The question is that this House agrees to Government Amendments A and B in lieu of Lords Amendment 106. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to the government motions to agree to the remaining Lords' amendments. I will put a single question on the government motions to agree to Lords' amendments 1 to 31, 34, 36 to 45, 48 to 53, 55 to 97, 100 to 105, and 107 to 143. Minister to move formally.
I beg to move.
The question is that this House agrees with the Lords in their amendments 1 to 31, 34, 36 to 45, 48 to 53, 55 to 97, 100 to 105, and 107 to 143. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. Minister to move that a committee be appointed to draw up reasons.
I beg to move that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments 33 and 47, that Edward Argo, Scott Mann, Aaron Bell, Paul Holmes, Chris Elmore, Andrew Weston, and Chris Stevenson be members of that committee, that Edward Argo be the chair of that committee, and that 3 be the quorum of that committee, that the committee be withdrawn immediately.
The question is that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments 33 and 47. That Edward Argar, Scott Mann, Aaron Bell, Paul Holmes, Chris Elmore, Andrew Weston, and Chris Stevens be members of the committee, that Edward Argar be chair of the committee, that 3 be the quorum of the committee, that the committee do withdraw immediately. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. That concludes consideration of Lords' amendments to the Victims and Prisoners Bill.